We're going to get started. My name is Stephanie Goldstein. Today's topic is a short one and relatively uncomplicated one, but nonetheless still very important and critical to discuss, and it's the importance of advanced directives for you and your college students. Now, one particular theme that we discuss in the estate planning and the elder law world is that it's never too early to begin the estate planning process, and that remains true for your college student. Now, yes, estate planning is not a particularly fun or even a comfortable topic to discuss, but it's important to discuss with your college student or any student over the age of 18 or exactly 18, as when your child turns the age 18, you, as the parent, no longer have legal authority to make any decisions medically or financially on behalf of your child. So there are numerous advanced directives that we always want our clients to sign, and we're going to talk about most of them because your college student can sign all of them. But there's a few biggies, the three big ones that I'm going to discuss, and a few others that I'll also get into as well. And these are documents you want to discuss with your child, whether they're already in college, whether they're 21, whether they're starting college in the fall, or whether they're still in high school and it's a couple years before college, but you want to just approach the conversation with your child to get them to realize that they're an adult very, very soon, or they're already a legal adult, and you want to continue to help them. And here's how you can do it. So the first document would be a power of attorney. This is a document that can allow the agent, the appointed person, or attorney in fact, whichever they're interchangeable in this respect, to perform and conduct and assist the person or the principal with financial matters. Now that can be all matters relating to banking, it can be signing contracts or negotiating contracts, it can be filing tax returns if necessary, filing taxes on behalf of your child. But also importantly, in the event that your child, in case of an emergency situation, in the event your child becomes incapacitated, and though your child may not have a lot of assets at that young age, it's important to at least have the authority to perform those duties on behalf of your child. Before COVID, this would be a really great, the COVID-19 pandemic, this would have been a really great document if your child was going overseas. That's not so much these days, but it's really great to have just in case, they go overseas or they go overstate and they are overstate or at a different state in college and they're not just doing remote learning at home. You can help them deal with their landlord. You can help them sign a new lease. You can help them handle things when you're not there. But the more critical documents we want to talk about today are those advanced directives that deal with what happens to your child in the case of an emergency and can you help them medically. But before I get into those documents, I'm just going to back up a little bit. In New York, we have what's called the Family Health Decisions Act, which has been in place since about 2010. So it's been a long time. And that act basically just says that if a patient comes into a hospital and is incapacitated, that person can't make any medical decisions on their behalf. And they don't have any advanced directives in place. And I'm going to get into them. This act allows the medical professionals or the medical staff, administrative staff to contact the closest relevant relatives, contact you to talk about what course of treatment can be provided to this person. Now, there's a couple of steps in order to get here. The staff has to confirm that this person is indeed incapacitated, and the hospital and medical staff will have procedures in place. But what you're relying on is that these individuals have a knowledge of this act. And you don't want to be in that position where you find out that your child was in an accident and your child didn't have a healthcare proxy in place, but hey, you're the parent. I want to know what happened to my child. They may not talk to you. You run that risk. They should be able to talk to you based on this act, but things happen, and we don't want to be in that position. In addition, if your child is out of state, the Family Healthcare Decisions Act is New York specific. Another state may not have a similar statute. So the doctors would be the ones making the decisions on your child's behalf. And those decisions may not be in line with what your child would want. And you, as a parent, would generally know what your child would want. And if you speak with your child about these documents, you'll get a sense of what your child wants. Which brings me to the first document regarding the medical treatment for your child you want to have. And that would be a healthcare proxy. In some states, this is referred to as a medical power of attorney, but they mean the same thing. It's allowing someone as agent, as proxy, to be able to make medical decisions on behalf of a patient who is incapacitated and can't make those decisions on his or her own. So in the case of an emergency where your child was in a car accident, and you were designated as healthcare proxy, the hospital can speak with you. And you can be involved in that process of determining what's the best course of treatment for my child. I'm the parent, I know what's best. I also know exactly what my child would want. I had a conversation with my child as to what kind of treatment he or she wanted. Which brings me to my next point. There's another document you also want to discuss with your child, and that is called a HIPAA Release form. Now, the HIPAA stands for Health Insurance Portability and Accountability Act. It's a long-winded act. What it does is it prevents the unauthorized access of legal adults' private health care and medical information. So even though your child is young, 18 years old, in the eyes of this act, they're 18. They have the ability to make decisions on their own behalf. This document, this release, is not necessarily as broad as the healthcare proxy in that a person who is able to look at medical records based on this HIPAA release, your child can say, my parent is allowed to look at my medical records. My power of attorney is able to look at my medical records. But this person is not necessarily able to engage in a decision-making regarding the course of treatment. They really can only look at your medical records and perhaps have that conversation with the doctor as to what's going on. How is my child doing? Again, you don't want to be in a position where you're relying on people to know the law, where you're hoping that some person will take pity. This is your child that's in a hospital bed. As an extreme example, our firm was involved in a matter. I won't get too much into the details, but this person was over 18 years old, and this person had a history of suffering from emotional injuries, unfortunately, but this person had high-functioning autism, and this person ended up in the hospital. And the parents found out, but they were unable to speak with the doctors as they were not healthcare proxy over this person, and they didn't have a HIPAA release. So we had to get involved, and it took several weeks before the parents could speak with their child and find out what's going on with my child and when can my child be discharged. So the last thing you'll want to do when in the event of a case of an emergency is call up an attorney. We're here to help you, but it's just more helpful to have these documents in place to prevent that next step. You're already going to be under a lot of stress, just trying to determine what's going on. So it's great to have these documents in place. Now, another document that would be helpful to have, may not necessarily be something you want your child to sign or your child would even want to sign, is what's called a living will. Now, this is a document that considers the end of the life of the person. For example, this person is in a hospital and is incapacitated, and by that I mean this person is in a coma and on a ventilator, and the doctors do not expect this person to recover. This person is not on a ventilator because of COVID-19, and they're expected to have a recovery. They have some sort of brain injury, they have a terrible disease, and they're not going to recover. What this living will does is it gives the person that's authorized to make medical decisions, the healthcare proxy, instructions on as to what my end-of-life treatment, if you will, should be. It can be take me off life support, or it can be keep me comfortable. Perhaps something will come along the way. This is not something that children really sign, but it's just something to consider. Because in the event, of course, this is unlikely, and this isn't the case of an emergency, a healthcare proxy, a parent is confronted with the reality that perhaps this child was in a car accident and is in a terrible coma. This healthcare proxy is tasked with making the decision whether to take this child on or keep this child on life support or take the child off life support. And it's terrible. It's a terrible situation, but perhaps the conversation about what the child will want would be very helpful to the healthcare proxy, because that way the healthcare proxy knows that by doing A, B, or C is in line with the person's wishes. So again, not comfortable, not fun to talk about, but accidents happen, terrible things happen. And to have these documents in place, a power of attorney, a healthcare proxy, a HIPAA release, these are important for everybody to have. Certainly important for your children. Now, one other document that I wanted to speak about that is gaining more and more popularity is what's called a Psychiatric Advance Directive. Now, it could be called something different in many different states, but it's referred to as a Psychiatric Advance Directive in New York, or a mental health care proxy. Now, there's no statutory form like a power of attorney or a healthcare proxy or HIPAA release in New York, but it is becoming more and more recognized by individuals or treating medical staff in hospitals regarding what the person would want for mental health treatment in the event of a crisis. This healthcare proxy who is appointed under this document can review this document and interpret or know exactly what the person would have wanted in the event they end up in the hospital due to a mental health emergency. This document can be very specific. It can lay out the types of medications the person does not want to be on to recover from this emergency, this mental health crisis. Another could be, I'm aware of this facility. I don't want to be brought to this facility. I don't want to go there for treatment. Another could be this particular doctor. This doctor knows me. This doctor has experience with my medical and my mental health history. I want to be treated by this doctor. And I want my agent to be able to communicate with this doctor because I know that they'll honor my wishes. Just checking the chat. I see there's a question. Are these forms transferable state to state, or do you need separate documents for different states? That's a great question. You've actually beat me to it. That's one of the things that I'm going to bring at the end, but let me just explain. As long as your document, if let's say you're in state, you're in Oregon, as long as those advance directives follow the laws set forth by Oregon, it would be honored in New York. However, it would be prudent, say you live in New York and your child is in Oregon or another state, it would be prudent to have New York advance directives in place and those states advance directives in place, just in the event that you want to make sure that everything is seamless. For example, as I mentioned earlier, a healthcare proxy in New York could be considered a medical power of attorney. So you don't even want medical staff to hesitate whether these documents mean the same thing in these states. So it's just helpful to have documents, certainly in New York, the home state, or wherever that person is living. Where do we get the form and who do we submit them to? Okay, great questions. You can come to speak with us. We have these forms available to you. A power of attorney is a statutory form, but it's definitely prudent to speak with an attorney to make sure that what the person that's signing the document knows exactly what they're signing and what kind of authority they're granting to the agent. Or perhaps there are certain powers in that document that the person does not want their agent or attorney in fact to have. So it's really great. It's better to meet with an attorney to go over that document. And the same thing with a healthcare proxy. And just to let everyone know, just for your reference, on our website, littmankrooks.com, we do have a healthcare proxy and a HIPAA release form readily downloadable for you to look at and definitely go over these documents with your children. Okay, just making sure. Okay, and who do we submit them to? Okay, for a bank, you would submit the power of attorney. Some banks are a little tricky. They have their own forms that they want you to fill it out. There's a new law that has come down that will become effective in the summer that requires the financial institutions to honor this power of attorney document. But for now, submit the power of attorney that you went over with an attorney, and also sign the power of attorney form the bank requires. For the healthcare proxy and the HIPAA release, those are documents that can be provided to the doctor or the hospital. It's even prudent for your child to have a little card in their wallet or their purse that shows my parent is my healthcare proxy, please call this number. And the same thing with that psychiatric advance directive form. They can have a card in their wallet they carry around. So in the event that emergency personnel have to take them to a hospital, they can get into their wallet and see, this is the person I should be contacting. And that person can provide those forms to the hospital. Are these forms the same as having the child classified as a disabled adult? Okay, so in order to be able to sign these documents, the person has to have capacity. They have to understand what they are signing. Now, if your child is on the cusp of having capacity, or perhaps a guardian is the better avenue, someone to make all legal decisions on their behalf. It has more power than a power of attorney document. That's something you'd want to come in to speak with us about. We would be able to speak with your child and get a sense of whether it's appropriate for them to sign these documents, or whether the parent filing an application in the appropriate court to become a guardian is more appropriate for this person. And to that end, and thank you for asking this because it brings me to my next point. These documents can not be signed by someone who loses capacity. Once they are signed and they then lose capacity, they are still valid. But the person cannot re-sign these documents or sign them for the first time after they've already lost capacity. Okay. So just a little food for thought. Again, if your child is going to be out of state for college or for vacation for a long time, or overseas doing externship programs, it's great to have these documents in place. A power of attorney for financial matters, for banking purposes, for dealing with landlords, for dealing with contract issues. A healthcare proxy to make decisions on your child's behalf in the event of a medical emergency and they're incapacitated and they're unable to make those decisions for themselves. A HIPAA release to be able to speak with the doctors and to at least obtain records, but not necessarily to make decisions. And the Psychiatric Advance Directive. Okay, but what about, here's the next question. What about people who really did not have capacity but signed forms that you question? Okay, so that's why it's best to really meet with an attorney. Certainly for a power of attorney, you want to meet with an attorney so the attorney can get a sense that this person has capacity. And if you believe that this person really doesn't have capacity and you're having this person sign, if this is a child, it's probably best not to have them sign. Again, come into an attorney. We'll meet with you and determine whether it's best to have them sign, or whether you should be seeking relief from the court to be appointed as guardian. Because perhaps some time down the line, the document could be challenged in court, and the court can receive evidence that perhaps this person didn't have capacity when this person signed it and revoke it. So you really don't want to be in that situation. So it is best to meet with us. And to that end, these documents are revocable. So when you're meeting with your child is not quite 18, but close to it, your child is 18, your child is a little bit over 18, let them know that the purpose of these documents is not to really control their lives. It's not to be a helicopter parent. It's just to help them. Once they're 18, they're adults and they need to grow and become more independent. But these documents are to protect them. We all should have these advance directives in place anyways, and they're certainly important for your child. Okay. Are the forms you have downloadable specific only to New York? So yes, so our documents are specific to New York. As I mentioned before, they are documents that can be transferable to other states, but just out of an abundance of caution, you might want to look into those states as well. If your child is a student of another state, of a college in another state, contact the university. Let them know that you'd like to obtain a copy of any downloadable forms they have, and they can be able to provide them. Which brings me to my next point. This is not necessarily something that's required. It's more preferable. Is a FERPA form, or FERPA waiver, sometimes is what it's called. And FERPA stands for the Family Education Rights and Privacy Act. It's been in existence for quite some time. It's similar to the HIPAA Act, but it's designed to protect students' rights to their educational history, their educational records, and their financial records relating to their education. So before a child turns 18, a parent has a right to contact a teacher, get an update on how the student's doing, see how their grades are doing. But once that child turns 18, the school really can't talk to you unless that your child is a dependent for tax purposes. Otherwise, your student has all right to privacy with respect to their grades, with respect to communications with their teachers, and with respect to privacy with their financial documents relating to their education. So it's something you might want to talk to your child about. If it's an instance where you are paying for the child's school, and just say, hey, I'm not trying to control you again, but I'm helping you afford this education. I just want to be involved. I want to be here to support you. So another food for thought is to consider how you sort of frame the conversation. Again, it's not to be a helicopter pilot. It's not to expand your authority over them. It's just to help them. And these are documents they're going to want to revise and revoke and add new agents to. They will want to have an agent as their power of attorney, and you want to have them name a successor. So whether it's mom and then dad, or vice versa, or whether it's a trusted aunt or uncle, or an older sibling, you want to make sure that they have their agent and their successor agent. Same for a healthcare proxy. You can only have one agent appointed as a healthcare proxy. By contrast with the power of attorney, 2 agents can be appointed as the primary for a person, but it's better just to have one, because then you don't want competing ideas as to how to deal with financial matters. So that's why with healthcare proxy, there's only one agent. You don't want 2 agents to compete to determine what's appropriate. Okay, but it's very beneficial to the child to have one agent and then a successor, or perhaps a third, but definitely have a successor agent. Okay, and that remains true for the healthcare proxy and the Psychiatric Advance Directive, or mental health care proxy. Okay, just checking over my notes. Are there any other questions? Just checking the chat. Okay. So as important as it is for your child to consider having advance directives, you know what I'm going to tell you. You should also have these advance directives in place. And every few years, perhaps it's every 3 to 5 years, perhaps it's more than that, you want to take a look at your own estate plan and consider whether your advance directives have the appropriate agents. If your child is 18 or getting older, you may want to name your child as an agent or successor agent, and they want to be able to update their own advance directives in the future. Perhaps they get married, or perhaps, mom, I want to work with someone else. Just have the conversation with them. The last thing you want is to not have these documents in place, and God forbid a terrible emergency happens. And not only are you concerned with your child's life, you're dealing with obtaining legal authority. So I'm just checking the chat for any other questions. I'm actually just going to check my notes to make sure I've covered everything. As I mentioned before, not a terribly complicated topic, but critical and great to talk about nonetheless. Okay. If there are no other questions, I just want to let everybody know that we have an excellent and very informative presentation scheduled for next week from my colleague Brian Miller. It's regarding estate administration, what to do when a loved one has passed away. Really informative, really important to know. So I hope you all join me and join Brian and join all of us next week, March 2nd, Tuesday at 12 o'clock. And no more questions. If anyone thinks of a question afterwards, please feel free to contact us, give us a call, or you can email MB, that's MB, at littmankrooks.com. Thanks very much, everyone, for joining. We'll see you next time.